Okay. So I'm going to show you my Idaho rules of procedure. Now remember, these are all basically based off of the rules of the common law. Because remember, these guys are what? At law? At
Right.
the common law?
Right. Or
You
supposed
see
to
their
be
sign,
at the
their
common
business
law.
signs. Counselors at law. This is
Right.
common law. And I've showed the video where that lady's teaching their students, her students there to pass the bar exam, preparing for
Right.
the test. It talks about the common law and shows the common law and all this other great stuff. And it's like,
Right.
okay, now that I put those little pieces of the puzzle together, all of these rules all come from the common law. And the ones
Right
that
on.
don't are the shit made up.
Right.
Okay. So when we look at this and we go, oh, rules of civil procedure and then rules of evidence and rules of family law procedure. No. These are all the same. And let
For
me
some
show you.
reason, Facebook is really zoomed in. It's kind of cut off part of the left-hand side. So
Yeah,
just
what
so
is
you
the deal
know,
with that? I fixed that
all
the other day.
yeah, all that's showing on Facebook is just the substance of what you're showing, which is okay. But if it starts to get any wider, like what you're sharing on the screen from
There, I fixed it.
Zoom, okay, yeah, it would be hard for them to see that. So
I mean, that's it. What's on? I see on Facebook. It should change here.
okay,
So, first thing we want to look at here. Get this stupid damn. General Administration. Scope of rules. These rules may be known and cited as the Idaho Rules of Civil Procedure, or abbreviated IRCP. Scope of rules. These rules govern the procedure and apply uniformly in the district courts and the magistrate divisions of the district courts of the state of Idaho in all actions.
right,
Proceedings and appeals of civil nature, except that proceedings in the small claims department are governed by these rules only as provided by the Idaho Small Claims Rules and family law proceedings as identified in Rule 101, Idaho Rules of Family Law Procedure, and governed by the Idaho Rules Family Law Procedure. All reference to these rules to the court or district court include the magistrate division, and all reference to judges or clerks include magistrates and their clerks, and a judge pro tempore appointed pursuant to Idaho Court Administrative Rule 4. These rules should be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. Let's see. Notice that it says, these rules govern the procedure and apply uniformly in the district courts and magistrate divisions of the district courts of the state of Idaho in all actions. All of them. That's a comma there. Proceedings and appeals of civil nature. Except that proceedings in the small claims department, there's the exceptions. It doesn't say exceptions to criminal. But if we go look at the Idaho Constitution, Article 5, it says, for violation of private rights and private wrongs is all civil. Whoops. So if it's all civil, it's all civil. All of it.
Right.
Civilized process.
So where is the level of civility here, right? Seems pretty simple to me.
So we start kind of at the beginning here, right? Now here's the commencement of an action. Proper service. This is, if this service isn't properly followed violates your right to service. Motion for dismiss for the grounds of insufficiency of service. Okay? There's your summons. Ooh, then what's this? All right. How to rule civil procedure 4.1 General Special Appearance. A. General appearance. The voluntary appearance of a party or service of any pleading by the party, except as provided in subsection B of this rule, constitutes voluntary submission to the personal jurisdiction of the court. Okay. B. Motion or special appearance to contest personal jurisdiction. The following do not constitute a voluntary appearance by a party under this rule. A motion under Rule 12b 2, 4, or 5, whether raised before or after judgment. Before or after judgment. So, even after you've gone to trial. So, if you do, we'll go to that, but let's look. A motion under Rule 40A or B, a motion for extension of time to answer otherwise appear. Okay, that's a continuance. Okay. The joiner of other defenses in a motion under Rule 12B, 2, 4, or 5. Okay. We'll go to Rule 12B, 2, 4, and 5. Response to discovery, pleading further and defending an action by a party whose motion under Rule 12, see, there it is denied. Still, filing a document. Notice it's in quotation that you have to file a document entitled Special Appearance, which does not seek relief but merely provides notice that the party is entertaining a special appearance to contest personal jurisdiction. If a motion under Rule 12b 245 is filed within 14 days after filing the special appearance, or within such later time as the court permits. Usually, it's within 21 days, because you have the right to respond to that petition. Okay. All right. Now, we'll go down here to Rule 12 so we can get a good comprehension what a motion to dismiss is. Defenses and objections. When and how presented. Motion for judgment on the pleadings. Consolidating motions. Waiving defenses. Hearings before trial. 12b is how to present defenses. Well, let's look at that. Start with the beginning. In general, unless another time is specified by rule or statute, the time for serving a responsive pleading is as follows. A defendant must serve an answer within 21 days after being served with the summons and complaint. 21 days includes the day of service. A party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim or the cross-claim. That's the response to the petition. That's the answer or complaint. A party must serve a reply to an answer 21 days after being served with an order to reply, unless the court specifies a different time. How do you present your defenses? Every defense in law or fact to a claim for relief in any pleading, whether a claim, counterclaim, cross-claim, or third-party claim, must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. This is motion practice, folks. This is part of your being sui juris and performing your administrative duties. Again, must be in writing. The title of the motion is Motion to Dismiss, and these are your grounds. Lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, which is actually, they changed, that's that word salad, but improper venue meaning wrong jurisdiction, the wrong district. Insufficient process, insufficient service of process. So 4 is due process of law, 5 is insufficient service. They failed to serve you properly and timely. And there it is. Rule 12b-6, right straight. These are all copied right off the Federal Civil Rules of Procedure. Failure to state a claim upon which relief can be granted. There it is. Now, what does it mean for a failure to state a claim for damages for which relief can be granted? Well, first of all, you have to be the injured party. You got to have standing in law to claim a right to a cause of action. What is the name of the man who has standing in law to claim a right to a cause of action here? We'll start there. And then we'll go back to the proper form of a complaint. Complaint must, with certainty, declare what was the right that was violated, what was the conduct that violated that right, and what are the damages.
Right on.
Okay, so if that isn't in the complaint, then that's failure to state a claim upon for which relief can be granted. Because they can't grant any relief if there isn't an injured party here claiming their right to a cause of action. They can't cite the law, not a statute, because statutes
not a code,
are not law.
not a rule.
The legislature doesn't make statutes, so who makes statutes? Right? Those of you that are new, that haven't heard that before, and those of you who have heard before, again, I repeat, who makes statutes?
You mean
the
them
legislature makes?
unconstitutional
Hold on.
act?
The legislature makes public law, policy, and
Acts.
private law, resolutions for violation of private rights and private wrongs.
Mm-hmm.
So, an enactment of the legislature is not law. It's policy. So, again, who makes statutes?
That would have to be them unconstitutional anal oppressive ones that come from those code commissions, those bar members.
Which is why Judge Eisman laid it all out in 2014 why the Idaho Code is not law.
Yep.
Code, think about it. The word code. It can't be law. They're speaking in code.
Yeah.
I don't understand code.
Whoops.
Whoops.
That's what I said. Well, that's our. Then again, our joke.
That's a foreign language, is it not?
Yeah. Well, and again, we were joking about this in the pre-show, right? They're talking about their code, their title, blah blah blah. I said, well, here, let me show you mine. You showed me yours. I'll show you mine. I brought in the Weatherly catalog system. Now you make heads or tails out of this. I don't know anything about that. Exactly. Nor would I expect you to. So how is it you're expecting me to be held to the same standard of whatever you're calling whatever it is you do, right? Knowing full well that I specifically chose to not do that job for a very good reason. I wanted to do this job, this code, right? And here's the law that this code conforms to. Can you show me yours? I showed you mine.
So I want to make this very clear. This is basically a one-page document. The motion to dismiss is a one-page document, 2 at best. Okay? Keep it simple, stupid. Keep it so simple that it is stupid.
Right.
This is not as hard as people are trying to make it out to be. The notice of special appearance objecting to the personal jurisdiction is less than a half of a page. You're going to take up more of the page doing the caption and addressing who you are and who they are in the court in the caption than the actual sentence that you're appearing specially and not generally, and you're objecting to the personal jurisdiction. We got to get this down, folks. This is pursuant to the rules of the common law. Pleadings and practice of the rules of the common law. This has been around since 600 AD with the Roman civil law. Been around a long time. This is super simple. Okay? Don't make it more complicated than it needs to be. And I'll go right with, the going thing, even before I met Chris, was a going thing. Less is more.
I have a real problem with that. And the reason I joke about this is because, mine is, my report's 1,450 some odd pages, right? Yeah.
Right.
So
Right.
you understand my problem. So it's not that I'm being mean or, condescending or anything. I'm just saying that's tough for a guy who spent his life having to be very detail oriented. Let's just put it that way. So, again, for those of you who suffer from that, I get it. Trust me, I so understand it. I get it. So, anyway, didn't mean to interrupt.
And remember now, what happens here is when they fail to respond with what's called a motion in objection to the motion to dismiss, right? And you don't put in there that you're demanding oral argument. In fact, you put in there in the motion at the bottom that you're demanding everything to be in writing. Okay? So, it's a notice of a special appearance objecting to the personal jurisdiction. That's it. That's the title of the document. Comes now, your name in proper English, and you're objecting to the personal jurisdiction. I do not consent. I do not acquiesce. Okay? One page. Same thing with the motion. Should be one page. 2 at the most. And then, of course, you have to have a certificate of service that you're stating that I put this in the mail or however you served them, right? Properly served. Because you don't want your motion to be dismissed for insufficiency of service. Works both ways. So you have to serve them, and then you do the certificate of service or I don't know. What was the other? There's another term that they use in some other states, but affidavit of service, right? Certificate of service, what we use in Idaho. Basically, it just says I deposited the foregoing document entitled the name of the document in the United States mail, and I sent it to, and you list the name and the address of who you sent it to. That's your proof of service. That's your evidence. So when you go for the motion for default judgment, you have the evidence to prove that you served them with the notice of special appearance objecting to the personal jurisdiction and lack of subject matter jurisdiction, right? See, in your motion, you'll have your grounds list. I mean, this is it. Right here. The way it's laid out right there. Lack of subject matter jurisdiction, lack of personal jurisdiction, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted. There they are, right there. I didn't write it, but that's what it says. Could damn near just copy and paste this right into a Microsoft Word document or any kind of a WordPad, anything, and you're damn near done.
Right. Yeah, I mean,
Okay?
it is.
And then you have to have a brief memorandum of law with points of authority. It's personal and subject. There's two different jurisdictions there. You got the wrong person. See Hale versus Hinkle. Okay?
Okay. See?
The judge is not a party to the case.
Yeah, a judge cannot be party to a case.
No.
Yeah.
Judge is not a party to the matter before the court. They're a referee there to call balls and strikes.
Right.
And see, again, we're here to create our court of record, which is documents. Has nothing to do with the building. It has nothing to do with a judge who's really not a judge.
Right.
We can get into some other issues called abatement issues, such as where's the law of your creation of this court? And I'm going to demand strict proof in accordance with the rules of evidence that you provide the law of your creation. What's your scope and authority from the legislature, not your rule of procedure?
You mean
Because
what we did
rules
in
of
Nate's
procedure
case?
are not law.
You mean what we did in Nate's case when we said, where's the word Constitution in this order? You can't claim that you're providing constitutional protections when the word Constitution doesn't even appear in the establishment of the emoluments of the 446th District Court. Can somebody explain this?
Stable on this machine, but not the other machine. And OBS is running just fine over there on that machine.
That's weird.
Oh, OBS is reconnected successfully.
Ah, okay.
I wonder if there's an update for OBS.
Whoops.
Oh. Okay, hopefully. All right. I just did a refresh on my YouTube so I can see it.
Uh-huh.
Because it freaked out on me too. So, all right. So we're going to go back over here. Now, after the pleadings are closed, but early enough not to delay trial, a party may move for judgment on the pleadings. Default judgment. Or summary judgment.
Right? And of course, we need to interject here that we know damn well they're never going to grant it. But that doesn't mean you don't ask for it. Right? Because the court's going to say, well, they never asked for it in the courtroom. The legislature's going to pick it up and go, bullshit, I'm looking right at it. Right? So this is why we
again,
say establish your
you're
record.
jumping from one jurisdiction to another. You can't intermingle the two jurisdictions.
If you want oversight, right, say you're explaining to me, right, this is why I say, what pillar of law are we talking about here? What process are we talking about in this pillar of law? Because according to the Constitution, the first pillar of law, the people have all the political power. So
Right, but
Even
we're talking about right here specifically in the judicial branch, your administrative duties and creating your
but
court of record.
I'm explaining why it's important, because I know I'm expecting the comments. Well, why put it in there? Because they're just going to say no anyway. You know, that defeatist
Because you're there to
thing.
create your record, which is your
Thank-
evidence. So when you do
Right.
go to the legislature and
Yeah,
you order
that's what
the
I was just
investigation to
saying.
verify your claims in the complaint,
Right.
and it goes over to the executive branch for an investigation,
Uh-huh.
you have
That
the
is-
evidence from the court of record to prove that you followed due process of law.
And that's exactly
And they
what I was
didn't.
just getting into saying before you cut me off. So you didn't let me finish. I was
Okay.
getting there. So, you know, we get it. We know. We understand what their shit made up is. They're so arrogant, right? Every one of those bastards is that arrogant. They're so arrogant that they don't even know how arrogant they are. They've lied so many times. They've told so many lies that they don't even know what lies they're telling. So when they, oh, well, they never said this or they never did that or blah, blah, blah. And even the senator or congressman can look up and say, well, I'm looking at a motion to dismiss, right? And in order for some request for order for summary judgment. Why didn't you do that? Right? I mean, what do you want the senator or congressman to do for you if you didn't attempt it? Right? So, you know, this is why we go through this. You know, we already know they're going to say no. But if you want the legislature to go in there and see for their own eyes of how we're getting fucked, sorry, couldn't resist. I had to drop one F-bomb tonight. But, you know, you have to show that, yeah, I did do it. Here's the process. Here's where I got it. So, you know, you can't say I wasn't attempting to play nice. So, yeah, when they start with their, well, he did this, and you know, he didn't, he didn't follow the process. He didn't follow the rules, and he's just a mechanic.
So I want you to pay attention to this right here, folks. Hearing before trial, if a party so moves, any defense listed in Rule 12b 1 through 7, whether made in a pleading or by motion, and a motion under Rule 12c must be heard and decided before trial unless the court orders a deferral until trial. Okay, here's the thing. If you do not request an oral argument on the motion to dismiss and you file a brief, there is no oral argument. There is no hearing if they do not object. Right? They have to file a motion, and when you're doing your motion, that shifts the burden of proof. They have to prove personal jurisdiction. They have to prove subject matter jurisdiction. And 9 times out of 9, they can't. They will not respond. Why? Because they're all playing in code.
Right.
And code is not law. None of it. Plain and simple. What was it? Rule 40? That's that one that was earlier.
You talked about a Rule 60D Delta more than once. Maybe you ought to cover that one again as well once you get done with
Say that
the
again.
40.
I couldn't hardly hear you.
So I know you were getting ready to go to a 40. Also, don't forget to talk about a Rule 60D Delta and why that's so important.
Right, but that's after an order. That's after. Right.
Right. But there's a lot of people that have just joined us, And you're a lot better at explaining the 60D than I am, because I'm just very matter of fact about it. And that's why I said I suck with the redneckinese, which is why I'm kind of leaning on you for this a little bit.
Now, look at this. Jury trial, trial by jury. Which is it? Well, the law says we have the right to a trial by jury. The jury is the judge. The judge is actually a referee. When somebody says objection, that's about the only time the judge, alleged judge, gets to speak. Other than that, he's supposed to remain silent, sit there, and be a referee and make sure that nobody's in contempt of the court, your court, because that would be a breach of the peace. And any orders that you have made or they have made, that nobody's in contempt of that order. But in the very beginning, there are no orders, so you can't be in contempt of a lawful order that doesn't exist.
Right.
And at any time one of these jackwagons try to tell you, well, I'm going to find you in contempt, then you say, under what lawful authority? That's the question. And I need you to cite the law. What lawful order did you give? Remember, lawful, not legal. Legal is contracts. We're dealing with full of law, due process of law. Now let's look at 38 real quick. Right to jury preserved. The right of trial by jury as declared by the Constitution or as provided by a statute of the state of Idaho is preserved to the parties inviolate. Now, not by statute, by the Constitution, because due process of law comes from the law of the land. And again, who in the heck makes statutes? Oh, that's right. Nobody.
After the bar?
Nobody in our form of government has the lawful authority to make due process of law.
So basically, that's a bunch of guys sitting around in their underwear on beanbag chairs eating Cheetos. Right? It might as well be.
See, then they switch verbiage. You got to watch the verbiage here. Remember, rules of procedure are not law. The Seventh Amendment is law. Remember, rights are law. In Idaho, the same provision essentially. I can't remember which one that is, but the due process of law, you cannot be deprived of life, liberty, or property, an aggregate of guaranteed rights here, without a jury. And this is how you demand it. On any issue triable by right of jury, so if you're talking about life, liberty, or any of my aggregate of guaranteed rights, any personal property of the such, you have the right to a trial by jury. It remains inviolate. You cannot violate that at all. And no rule of procedure, no city ordinance, no regulation, and sure as heck not any statute that doesn't have any standing in law to begin with. So, again, back to administrative duties. A party may demand a jury trial. No, we don't demand jury trials. We demand a trial by jury, because that's what the right dictates in the history of that. Serving the other parties with a written demand which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and filing the demand in accordance with Rule 5D. You have to file it with the court. In its demand, party may specify the issues that it wishes to have tried by a jury. Well, it's the Idaho Code law. But I know for a fact that they don't respond, because I've already done this. Okay? They will not respond because they can't prove it. And they know they're busted. When they pick up your motion and your brief memorandum law with points of authority, they know they're done. This is why they want you to have a member of the bar to represent you, because as soon as you hire one of them, you're saying that you're incompetent, you're not of sound mind, and you're not capable of handling your administrative duties. This is the game they play, and because all of these statutes and all these rules of procedure, that it's done on purpose to make it seem like it's so complicated that you got to go to law school for 7 years to learn this stuff. No, I'm here to tell you, no, you don't. This is so simple, it's frickin' stupid. It really is.
My joke, if I can figure this
And
out.
we get into 39. When a demand is made, when a jury trial by jury, the action must be designated on the register of actions as a jury action. The trial on all issues so demanded must be by jury, unless the parties or their attorneys file a stipulation to a non-jury trial or so stipulate on the record. The court on motion or on its own finds that on some or all the issues there is no right to a jury trial. Now, when these jackwagons try to assert that power, well, no, that's not triable by a jury. I look forward to reading your findings of facts and conclusions of law on that. And you file a motion to demand that they produce a findings of facts and conclusions of law. Put it in writing. Hold them accountable. Don't let them get away with running you over. Make them put it in writing. And then when you do that, you can do a motion to reconsider. That's his get out of jail free card once he knows he's busted. When you demand that, he or she may decide to reconsider their opinion. Because we all know what opinions are like, right?
Right.
See, everything is by consent. And notice they're using jury trial, not trial by jury. There is a difference. Don't let them tell you that there's no difference. No, a jury trial is done by them. And it's a mock trial. A trial by a jury must have unanimous consent to find guilt for criminal in nature. Civil in nature requires 3/4. That's the only two types of juries we have. And it's of 12 men, unless you agree to something less than 12. Now, another key one here to know, this is where we really hammer them. They don't want you to know this one, so pay attention. Oh, well, I suppose I should go back. These rules are titled and should be cited as Idaho Rules of Evidence or abbreviated IRE. Scope. These rules govern all cases and proceedings in the courts of the state of Idaho and all cases and proceedings to which the rules of evidence are applicable, except as otherwise provided in this rule. Rules on privilege. The rules of privilege apply to the stage of the case of the proceeding. Rules applicable in part. These rules apply in the following proceedings subject to enumerated exceptions. Preliminary hearings, except as modified by Rule 5. Proceedings under the Juvenile Corrections Act, except as modified by the Idaho Juvenile Rules, which is all lack of personal jurisdiction. Lack of subject matter jurisdiction. Because national rights and civil rights have nothing to do with the establishment, support, or management of government. Back to the first fundamental principle of group decision making. You ain't got subject matter jurisdiction there, legislature.
Don't.
See how they try to exempt all these rules of evidence?
Uh-huh.
Oh, what? All these informal hearings for emergency medical treatment. No, we don't have to follow any rules of evidence. Citing Idaho Code. Idaho Code is not law. Idaho Code. Idaho Code is not law. See, court of record includes a memorandum, report, or data compilation. Huh. A reference.
I want to address a comment on YouTube. David brings up an interesting point. Brings up Title 42. Who created Title 42? Whether
Bingo.
it was totally ratified or whether it wasn't, neither here nor there, right? Because there's been plenty of discussion that wasn't even properly ratified. So
Remember,
skipping
code is not law.
again, who created it? That
Yeah.
was an act of
Who
Congress.
created the United States Code?
Well, that's the bar member stuff, right? So
Yes, sir, indeed.
what we're also talking about is on so much as Title 42 being a civil redress process, right? That is concurrent with the Title 18 criminal process, right? That was the legislative intent of Title 42. It's still a legislative process. You have to go to the legislature. I mean, that's why you have to. That's why we say it's as simple as 1, 2, 3, right? So if you follow steps 1 and 2, right, redress your grievances with your legislature, take your time, do it right, right? Some of the stuff you can take from the rules of the court, some of the stuff you can take right from the bar itself, right? You published it, hey, it is what it is. So here's the law. Here's what is currently recognized. We'll call it tradition if it makes you happy, right? And again, anything they say, right, can and will be used against them in a court of justice, which is still the legislature. So, and what happens in so much as any person in emolument, right? Somebody on the clock. The process that is due them still boils down to impeachment. So I said, if I'm in a position of emoluments, how I know this, right?
Mm-hmm.
I was not impeached before I was imprisoned. That was insufficiency of process. I was not afforded due process of law. Oh, snap. Good point, Mr. Hallett, right?
Yep.
So
See,
you're doing it right.
here-
Keep going.
Here's the same thing I keep hearing people say all the time. Mary Beth Matthews out here on Facebook. They are criminals on the bench. They don't even know the constitutional rights and violate them freely in all court hearings and trials. Well, duh.
Right?
Quit playing their game. Follow due process of law. Be sui juris and perform your administrative duties. Create your court of record so you have an evidence to prove that they're criminals. Burden of proof's on the moving party. If you're going to assert that you have these rights, that's on you to put in writing. That's on you to put it in the record and assert. Remember, he's just a referee, calling balls and strikes.
Right.
We have to perform our administrative duties here. Quit making excuses for not doing your paperwork.
Right. And again, we open the show, right, with the letter of the law, right? So
they make this seem like it's so complicated on purpose so that you give up, and
right.
They play this game of try to oh no, I'm going to deny this, and you get all upset and you start going off, and they look at you like you're crazy. Okay, now you're incompetent. They do that on purpose,
Right. So by
to
the
mess
time
with
it
you, to
gets the
get you
House
to
of
act out,
Politics,
so they can deem you incompetent. You can't keep yourself under control and remain in honor.
Right. So what ends up happening is
your honor.